Good evening, everyone. This is Lisa Morgan, President of the Georgia Association of Educators. Thank you for joining us this evening for our session 3 of Rights at Night. And we are going to get started right away with our GAE General Counsel, Mike McGonigal, to tell us all about our legal rights concerning teacher keys, the Great Integrity Act, and disruptive students. Mike?
Yeah, thank you, President Morgan, and good evening, everybody. I can't begin a presentation on legal rights without at least plugging your GAE Legal Services program. It's important to keep in mind that our employment liability protection provides coverages greater than our competitors. Normally, our competitors do offer $1 million liability. We offer up to $3 million aggregate. So keep that in mind when people ask you about our liability protection, because all liability protections are not created equal. Ours is provides better coverage. The other important thing to keep in mind when discussing legal services with potential members is that we do not have any predetermined cap on legal fees or costs that we expend in defense of member rights. Other organizations have a cap of $10,000 per, say, an employment case, and they aggregate the amount that they would expend, say, an employment case plus a certification case plus a criminal case, and they aggregate that total to a predetermined cap. GA does not do that because you never know if you are going to be in a position that is going to require appeals up to the state board, superior court, court of appeals, or even the Georgia Supreme Court. So you need to share that with potential members. We also do something that's very different than other organizations, is that we file affirmative lawsuits. For example, defending your First Amendment rights in federal court, to take one example. A case such as that can easily expend $50,000, $60,000, even over $100,000 to vindicate your First Amendment rights when advocating on behalf of your members through your local association. So please keep those pieces in mind when you're approaching non-members or potential members and having the one-on-one conversations explaining why legal services is superior to other organizations. So just a quick overview. So where do our rights come from? Our rights are not created out of thin air. They're created by federal statutes, state statutes, the Georgia Department of Education, and yes, even the Federal Department of Education. The Professional Standards Commission, which regulates your licenses and has jurisdiction over the Code of Ethics, and your local Board of Education. And the one thing you'll notice, your rights are created by those that we elect to the federal government, the state government, and the local Board of Education. So it's very important to understand and convey that education is political in that particular sense, that our rights are created by those whom we elect to public office. The last thing I'd say about local Board of Education policies, you should really know them, as we'll see in this evening's presentation on TKES. Local boards of education can amend and expand upon what the state TKES guidelines have in mind at the state level. Local boards can also modify and expand upon your TKES rights, your TKES procedures at the local level. So please, at some point, take a look at your local policy concerning evaluations. So I thought we'd start off a little bit about where we as an organization agree about the nature, purpose, and intent of the teacher evaluation and the leadership, the administrator performance evaluations. And I brought these bullet points up back from when the law was initially adopted back in 2013, and there were numerous sore spots for us, and I'm not going to rehash all the history. I do want to emphasize the positive, that GA fully agrees that personnel evaluations are an important tool to identify strengths and weaknesses to provide professional support. So they are not to be used to intimidate or manipulate or coerce employees. And I will say the TKES and the leaks may seem or is an improvement over the old GTEP, Georgia Teacher Evaluation Program, that was in place many years ago. We now have an improved instrument, but an evaluation instrument is only as good as the administrator who is administering or implementing the tool. But we agree that evaluations, the intent is to provide support so that we can learn and grow professionally. The 10 standards themselves, they're a solid framework. We don't really have a particular issue with them. Again, it's how they are implemented. And lastly, and we'll get into a little bit more of this, that we agree that educator effectiveness can partially be gauged by using standardized pre-test and pre and post student assessment. And we'll get into some of the legal issues regarding TKES and some of the problem areas that I see or that we see regarding TKES and how it is structured and how it is being implemented. So everybody is probably pretty familiar with the teacher effectiveness measure, or the TEM. That is your overall rating, and it's broken up in these following subparts. 30% of your annual evaluation is supposed to be based on student growth percentiles. When the law was initially adopted, the language was, shall be at least 50% student growth percentiles. And our GAE did a very effective job at lobbying the state legislature to reduce that at least 50%, because that could have been 50 or 99% or 100%. It was that open-ended and unfair. And so I think through our lobbying efforts, and I believe Senator Lindsey Tippins at the time was very open to GAE and was very instrumental in listening to us in getting the student growth percentile changed back down to something that's a little bit more reasonable, I would say. Professional growth, that's to count 20%. And the growth, of course, is tied to certification, that a professional growth plan or it is based on PSC regulation at the state level. However, it allows local school districts to come up with individualized plans of professional growth tied to your certification. And so it goes from district to district to district, but that counts 20% of the overall TEM rating. And then, of course, last but not least is our TAPS, Teacher Assessment Performance Standards. Those are the 10 standards that make up the balance of an annual evaluation. That's your observations and your documentation record that goes, supposed to be ongoing throughout the year. The presumption of incompetence, ineffective rating, that's a personal sore spot for me, because what that does, that is in the TKES, or the State Evaluation Code 20-2-210, and what that says is that anytime an educator receives an ineffective overall rating, that gives the school district a evidentiary presumption of proof of incompetence at a fair dismissal hearing. So what that means in practice, that a school district just has to introduce your rating at a non-renewal hearing, let's say, without introducing all of the background that led up to why the educator was given an ineffective rating. I believe that that's an illegal provision in the performance or the evaluation statute. Could very well be ruled unconstitutional as well as a violation of your due process rights. But it is still there, and I will say that we haven't yet seen a school district try to utilize that provision in a non-renewal setting, and that's probably for the reasons that the school board attorneys are saying, hey, wait, you do this, and we're probably going to, even if we win our local hearing in front of the school board, we're going to lose on appeal if you follow this evidentiary presumption of incompetence based on an ineffective rating. But I put that in there just so everybody is aware of that possibility. Also, when an educator receives an unsatisfactory or ineffective performance rating, did you know that that year does not count towards your salary on the state salary schedule or on the local salary schedule? And there is no appeal from that salary freeze. GAE has proposed language in previous legislative sessions that would institute an appeal process, an ability to remediate the ineffective rating, and that would undo the freeze on the pay. So that is something that we'll continue to do in the future and as we continue to lobby. Now, the TKES is also tied to certification, not only your salary, but to certification. And the rule is that an educator who has 2 unremediated ineffective ratings within their 5-year certificate renewal cycle is not entitled to or may not be issued a certificate. And there is no, at the moment, there is no appeal process. So if an educator receives 2 from a school district, it's unremediated, and let's just say that educator is then let go, they have no ability to go to the Professional Standards Commission to show that they have been remediated. So that is an effective lifelong ban on re-entry into the profession. And again, we have proposed language to address this situation, and we will continue to do this as we lobby the General Assembly moving forward. And as I mentioned earlier, local school districts, despite everything we have at the state level, issued by the State Board of Education regarding TKES and the manual that is shrunk from over 200 pages in the beginning to now less than 40 pages. That's guidance that local school districts can amend and expand upon your evaluation rights and evaluation procedures. So that is the overview on that piece. So you need, again, to be very aware of what your local policies and procedures are regarding your evaluation. So digging in just a little bit on the student growth percentiles, they are not intended to even measure teacher effectiveness, but that is exactly what Georgia is doing or is proposing to do. They are intended to measure student growth, but not causality. And that gets into these questions of how do you isolate the teacher's role in student achievement? In the real world, we all know students are not randomly assigned. but the student growth percentile algorithm, if you will, which is still seems to be a classified secret, assumes that students are randomly assigned, but in the real world, we all know that they are not. So that is one unfairness that needs to be addressed. And then we all know that students can have more than one teacher during the year. So how is it possible to hold Mr. McGonigal accountable when the student has had both Miss Morgan and Mr. Jones during the school year, and yet I am being held accountable for student growth? That's just part of the real world that's coming into that the abstract SPG algorithms do not take into account. And you have something what's called the ceiling effect. So everybody knows there are students that are test out exceedingly high all the time. And if that's the case, how does such a high performing student show any growth at all? And then at the same time, there is that floor effect, which at some point, somebody through some stroke of a pen has to come up with the floor that below which the floor is established arbitrarily. I would put it like that. But again, there are very serious, real problems in isolating the teacher's role and holding teachers accountable in the evaluation. And I believe it was, we said it was 30% of your overall evaluation is tied to indicia or elements that are way beyond your individual control. So that is something else that we'll continue to discuss with the state board as to whether these should be used in high stakes decision making. Our view is that they really should not, because that's not really what they're intended for. So some of the procedural issues, these are some of the things that we need to keep in mind as we move forward. And if you have a negative outcome without any narrative description, so you received a 2 rating, but there's no explanation, you should be ready for that. It happens. Or an observation, administrator comes in unannounced, which they can do during a time when you might be showing a movie to your class. Well, how fair is it to observe you during a time when you're showing a movie to the class? And is there a system in place where the administrator would come back at another time, or are they just simply going to plow through and put a rating down under a circumstance which is really quite unfair? But that happens, and that's something you should be ready for. Or, as also happens, nothing happens during the year, and if you're a new teacher in the formative observation process, you're supposed to have 6 observations, but come February, you haven't had any. And in February and March, all of a sudden you're getting 5 or 6 observations all at once. That is the type of thing that can happen. And we'll talk a bit about what you can do proactively to head that off at the pass. Common pitfalls that we see, just being passive, I would say, and not asking to reschedule. Again, observations can be unannounced, but we all have days or moments when we may not be at our best, or we have a particularly difficult class, and instead of asking the administrator to come back, schedule it at another time, they just simply allow the administrator to observe you even when you're not having your best day. And as we're all human beings and we're all fallible, in those situations, I think people need to speak up a little more forcefully. or signing the TKES without uploading any responses. You know, the mantra with us at GA is always document, document, document. And we should, you know, counsel and educate our members that you should, if you're going to sign the TKES, but you really need to upload your own response in the comments section. Never let it go unresponded to. Remember, the TKES evaluation is a legal instrument, and you're creating a legal record that is going to be used in the future, or very potentially is going to be used in the future by the school district in a disciplinary setting or a non-renewal setting. And so we need to be on our toes and be able to respond professionally to ratings that we may not completely agree with. And of course, in documenting a procedural defect by the evaluator through email or letter, which is fine, but again, the TKES platform is really the best record to respond to ratings and creating a very good record down the road. As a lawyer, I'm always thinking about, what am I going to say in front of the school board, or what am I going to say in front of the judge? And I want a record that is very clear and consistent, that I can point to, whether I'm rebutting incompetence or I'm trying to prove some illegal type of discrimination. So document, document, document is one of our best friends. Turning to the Grade Integrity Act now. In my world, I sometimes take it for granted that people know their rights, and I can't tell you the number of times I'll get a call, or a UniServe director will receive a call saying, hey, I'm being asked to change a grade. My assistant principal or whomever, lead teacher, is asking me to change a grade. Well, education's a profession. You're hired to make professional judgments, and you are entitled to assign the grade to a student based on the record as you've accumulated and as you have documented and can back up and substantiate the grade that you have assigned to a particular student. Well, a number of years ago, we had a law passed called the Grade Integrity Act, and that's the legal citation. And I put in the very first sentence of that statute: no teacher shall be required, coerced, intimidated, or disciplined in any manner to change a grade. That's period. And, full stop. A violation of the statute shall constitute an ethics violation. And here's the other important part, is that the law states very clearly that a central office administrator or school level administrator has the right to change the grade over your consent. And that's just, it may be something hard to swallow, but it says also that the record must clearly indicate that the grade was changed and indicate who changed the grade. So the administrator will be put on the hot seat or on the hook on this, not the classroom educator. You're entitled to make that professional decision. The law protects you from being intimidated or being disciplined for refusing to change a grade. It gives the central office or school level administrator the right or ability to change the grade and indicate who did the changing, so that that monkey is off your back. So turning to a very lengthy titled law that went into effect in 1999. The long title of the law is the Improved Student Learning Environment and Discipline Act of 1999. And I wanted to walk you through its various sections because, again, in my travels and President Morgan's travels and our UNISERV staff travels, we're finding out educators don't know that this law exists. And it might be because the school district does not want you to know about this particular law. So it was adopted in 1999. I give you the legal citation there, 20-2-735. And 735 says that all school districts must adopt and implement a policy relative to this law. It has to adopt student code of conduct. It must adopt a progressive discipline policy. And it has to have a policy language regarding parental involvement. All of those pieces and more are set out in section 735 of the law. So the next section, 736, hopefully your school districts are doing this, is the schools are required to distribute and obtain signatures of the students, parents, and guardians. And if they're not doing that, that's a violation of the statute. And if you're having difficulties and concerns with gaining compliance, you should contact GA for assistance in gaining compliance. 737, that's the next section. Mandatory compliance and reporting. And it states that within a day of the violation of the student code of conduct, based on the classroom educator's judgment, that there has to be a report made within 1 day. I believe the language is by the end of the same school day, but no later than the next day. And the report goes on, or excuse me, the compliance reporting goes on to state the reporting goes to the principal or designee, which is more than likely the assistant principal. And then there's also a requirement that's fleshed out in the next section, that where that report goes to, it goes to the parent or their guardian with the school's contact information. Call Principal Jones at this number to discuss this incident that happened in class today. That has to be complied with. So the next section, and this is the entire statute is very important, but this has a special subtitle to it. It's referred to as the Teacher Authority Law. And this was and still is a very big deal for classroom teachers. It gives the teacher the authority to manage their classroom, discipline, and refer students. That should go without saying, but this is in the actual statute itself. It goes on to say that the classroom teacher has authority to remove a student from his or her classroom if the student repeatedly or substantially interferes with the learning environment and conduct that violates the student code of conduct, and assuming that he or she has previously filed a report according to section 738 of the law, or if the student poses an immediate safety threat. Now, the next step in the process is, the statute goes on to say the principal shall fully support the teacher's authority. That was an amendment in a year or two after this law was implemented, because quite frankly, school administration did not want to implement the law, and we lobbied the state legislature once again and had that specific sentence placed in there to make it abundantly clear in statutory writing that the principal must support the teacher's authority under this statute to remove a student from the classroom. Now, there's a few hoops and hurdles if there's a violation. When you report it to the principal has to notify the parents in writing, again, within 1 day. The law requires the principal to meet with the student and the teacher at the end of the same day or next day. And then here's the big one. I should have bolded it and underlined it. After you have the meeting with the principal and the student, the principal can ask you to accept that student back into your classroom, but only with your consent. You have a right under the law to say, no, I do not consent and I do not wish to have this student placed back into my classroom. That was the whole point of the teacher authority law, to remove a disruptive student who has a pattern of disrupting the learning environment or poses an immediate safety threat, to remove the student from your classroom and not have them come back if you say no. So then what happens if you do not consent to the placement of the student back into your classroom? Well, the principal has to make a decision placing that student in a temporary placement pending a review hearing that's to be conducted by the placement review committee. Now, this committee, again, by statute, I didn't put it in a bullet, but the law requires at the beginning of each school year that each school elect a placement review committee. The committee is to be comprised of 3 individuals. 2 must be from the classroom, and 1 can be from administration or their designee. So if they are not conducting the election at the beginning of the school year, and here we are, it's almost October, that is non-compliance with the teacher authority law. So the placement review committee is in place. They have a hearing. They will hear the student side, they'll hear your side, and then they are to make a decision within 3 days to either, after hearing all the evidence, to return the student back to your classroom or to an alternative placement or appropriate discipline, including suspension, up to 10 days. And this particular law, of course, is overridden by special education law. So it isn't going to apply in the special education setting. Of course, special education has its own rights and responsibilities relative to disciplining special needs students. So I wanted to put in another slide, since we're focusing on our certified classroom educators, that there's other laws on the book that protect our school bus drivers, our administrative support personnel, our lunchroom help, our cooks in the lunchroom against physical violence. And so I put this slide up and gave you the citation, 20-2 751.6. I know that's a lot, but if you put that in, if you Google that, you can pull up this law, and there's a lot more to it. But I wanted to bring it to your attention that this law is in place to protect all school employees, not just classroom educators, but our classified employees, our school bus drivers and our lunchroom workers and our office assistants and bookkeepers. So please look that up when you have it, and share it with our members so that they are also aware of their rights, whether they are classified or professional employees. So that's the overview of our slides. We just want to conclude by always saying we are completely in this together. The pandemic has brought upon a lot of huge changes and challenges to all of us, but just know that GA is there. We're stronger together, and that Legal Services is always there to support you. We thank you for your membership, and of course, if you're not a member, we're certainly open to asking you to join our ranks, because there is certainly strength in numbers. With that, I stop the share.
Yes.
Stop the share. Okay, there we go.
Okay, great. Thank you, Mike, for that. I do have some questions, and some of the educators and members that are joining us this evening have already put their questions into the chat. If you have a question for Mike, please put it into the chat and I will ask him the questions. We have several already. So the first person said, the administrator who observed me was only in the classroom for 5 minutes, but they gave me ratings on all 10 standards. Can I appeal that observation?
Yes, yes. The short informal answer is yes. Now, the TKES handbook, again, it's available on the website, and I think we'll be putting it out, says that your observation should be 20 minutes. So right away, there's a procedural violation. And there's really 2 ways you can appeal it. One is you can file a formal grievance over a procedural violation through your local grievance policy. That sometimes gets to be a little time consuming. The other method is simply go talk with your administrator or call your GA Uniserve director and explain the situation and see if one of us can have a conversation with the administrator, because you cannot possibly rationally give a rating on all 10 standards based on a 5-minute observation. Remember, the intent of TKES is to help us grow professionally. So this scenario that President Morgan presented is in complete non-compliance with the whole intent of TKES, which we agree with. So it's definitely something that really must be appealed. Remember, you're creating a legal record to protect yourself for the future if necessary.
Okay, next question. I'm a new teacher, and in the standard process, I was observed 3 times in 4 days. All of the observations rated me low on the same standard.
Yeah.
I wasn't given an opportunity to improve. What can I do in that situation?
You really need to let us know. I mean, first of all, let us know. It's a situation that you have to appeal. The data in there is completely inaccurate. Remember, we agree with the TKES evaluation instrument, but the instrument is only as good as the administrator that's administering it. And again, so if you're observed, 3 or 4 times in a week, that is completely rushed. My hunch would be that's a scenario of administration not doing their job during the year. And so they're coming in the late winter, spring to catch up and check off boxes in the number of observations. So we really need to put comments in the comment section. We need to respond immediately. There's an appeal on procedural defects here that you should pursue. You can do that with GA's assistance. And again, keep in mind that is not the intent of TKES. If properly implemented, TKES is a helpful tool of professional growth. This does not at all comply with the intent of TKES.
So just for our members that are here today, I have put in the chat box the PDFs of the Teacher Keys handbook for this year, and also a couple of documents that are not in the handbook that can really help you. One of them is the examples of documentation, and this was in the handbook up until 2013,
Right.
and then they took it out. So would you recommend that teachers who are going to be evaluated under TKES, should we go ahead and upload things if we have them to the platform, or should we wait until they come and ask for it?
I think it's better to be proactive. Why should we wait and be passive and allow the harm to occur rather than being proactive and heading off that harm before it occurs? And I give President Morgan a lot of credit for keeping up with the handbook, the TKES handbook, as she noted, when it first was publicized, and I went through a process. It was over 200 pages long, but they've shrunk it, they've reduced it. Very important things that President Morgan just shared with you are no longer in the manual itself. You have to hunt for this particular document. And what she's saying is, at the beginning of the year, and she is a first-rate practitioner in this regard, at the beginning of the school year, she will upload comments relative to each of the 10 standards. Even before you are observed, you want to play some offense. Put it in the record up front before the observation as to what you're doing. So when they do observe you, they're going to see, hey, you know, President Morgan or Mr. McGonigal was actually doing this stuff. So you're actually shaping the evaluation in advance. You're protecting yourself. You're putting the ball in administration's court to actually do their job and to ensure a more level playing field by being proactive and uploading comments at the beginning of the school year. I think that's one of the most effective pieces of advice that we could really share tonight on that.
So this is particularly now, we do have some districts that even though they are still in virtual or hybrid learning situations, they are implementing TKES. So one of our teachers said, my administrator observed during a virtual learning lesson. So they came in the room, they came in on the computer virtually. They marked me down for my instructional practices and having a welcoming classroom because the children did not have their cameras on. And my district says we cannot require the students to turn on their cameras. I feel like I'm being penalized because my students don't want to turn on their cameras. How can I appeal this rating?
I think you can appeal it by, again, uploading comments in the platform. I mean, if you can't be penalized for following school district policy. Let's just put it that way. And so a low rating, and I assume the low would be a 1 or a 2, you're being penalized for following school district policy. So that rating it doesn't hold water. You're going to have to upload those comments, it seems to me, and challenge the rating itself. So it's, yeah, that would be a very unfair practice, because I think a rule or a policy of not having the cameras on, and it has a good intent, because there may be things in the home that the family may not want to share. Some of our lower socioeconomic areas, there may be very good reasons, privacy there, not to share the home environment. But at the same time, you should not be rated low for following the school district policy. That's what I'd say.
Okay. The next question is about the Grade Integrity Act. How will teachers know if an administrator has changed a student's grade? Is it mandatory that the teacher be notified that the administrator changed it?
You know, there's no language in the statute that requires that you be notified. But my best educated guess is that you're going to find out through access to your grading platform. So you're going to know that the grade was changed. And the key for your protection is that administration is required to indicate who changed it. And that may be something we look at, that to amend the Grade Integrity Act, that the teacher must be notified in the event that administration formally changes it. But I don't know of an instance where a grade was changed and our member didn't know of it, but it's a fair point to bring up.
This teacher said the parent of one of my students is best friends with the principal. So the principal asked me to give the student an A instead of the B he earned. What can I do?
Well, there again, the Grade Integrity Act gives you protection. What you can do is stand your ground. Now, you should be prepared to show all of the documentation to substantiate your grade, whether it's a B, a C, a D, or an F. Be prepared to have all of your ducks in a row, so when it comes time for something like this to happen, you're not going to be caught, in a weaker position. You want to be in a strong position to substantiate your professional judgment. And so certainly the Grade Integrity Act protects you from being intimidated or coerced or retaliated against or refusing to change the grade. And this is I suppose an all too common occurrence is that you have important, parents in the community and they're connected, or they're just, they're litigious type parents. But that at the end of the day, that's not your issue, because you're entitled to issue the grade that you feel is best in your professional judgment, but you should be ready to substantiate that your grade, because you want to be ready if administration asks you to change it. You have a right to say no.
Okay, next question. One of my students in my class has threatened to stab me with scissors. They were suspended in a former school for attacking a teacher. I don't want them to remain in my class, but the counselor says their schedule cannot be changed.
Can you repeat that, Lisa?
One of the students in my class has threatened to stab me with a pair of scissors. They were suspended at a former school for attacking a teacher. I don't want them to remain in my class, but the counselor says the schedule can't be changed.
Schedule can always be changed. I would say schedule can always be changed. So threatening to stab somebody is a crime. Even if this child was special needs, I don't believe a manifestation hearing would say that's a manifestation of their disability. So this should be reported not only to administration, but to outside law enforcement. And you should also, don't be intimidated in saying, no, don't go to law enforcement. We always want to be protective of the good image in the community. And we all are concerned about having a positive image, but at the same time, we cannot tolerate having students threaten any public school employee with a pair of scissors or anything else that could inflict a physical harm. Now, they were suspended from another school district.
From another school in the district.
Another school in the district. And they were it gets to the question about changing the schedule. They transferred the child to a different school. And the administration's response that they can't change the schedule is complete fabrication. They can always change the schedule. And I think the teacher authority law, again, gives you the right to remove the student from the class and basically don't provide your consent to putting that student back in your class. Puts the ball right back into administration's court, as uncomfortable as it may be for them to do their job. Now, the student may have to go to an alternative school, or the student may have to be suspended. There's a range of options that are available, but just simply saying we can't change the schedule isn't one of them.
Okay. A student has spent the last 2 weeks in and out of in-school suspension for being disrespectful and disruptive in the classroom. Can I have them move to another class?
Yes. Yes. So if that student is in your classroom, again, you can use the teacher authority law to remove them. The district can put them in a different class. And it's just yes. So I mean, the short answer is yes. Whether you use the teacher authority law or you just have a meeting with administration, they can always move the student to a different classroom. It's just the question of who is going to take the student that's disruptive. Is always who is the lucky teacher. But,
okay. We have another question from one of our members who is with us this evening. My county decided to return to school face-to-face and required all teachers to do so. I am currently taking chemo treatments and cannot return face-to-face. So I am on FML leave. How will that affect me and Teacher KES?
oh, yeah, great question. It will have no effect. The FMLA, FMLA is very strong in one regard, in that it has very clear language that the employee shall not be intimidated or coerced or be penalized for the use of FMLA. So the days that you are out on FMLA are protected and cannot be held against you in an evaluation. And yeah, and if it is, contact us, because that is one that we will get on very quickly.
Okay. So, and I'm going to ask a question kind of expanding that. So if she's not able to return until January, and so everything from first semester, there's no observations or anything, those cannot be held against her.
No.
They have to just go with what they have second semester.
That's right.
Okay.
That's right.
Okay. I hope that answered your question. And if anyone else has any questions, we'll give you just a moment to type them in. Those are our questions so far. I want to thank all of our members for joining us tonight. Thank you, Mr. McGonigal, for once again providing us all this great information about our legal rights that we do have in our classroom, and that our GAE members and our UNICEF directors are here to assist you with these rights. We will have our next session will be in October, and at that time we will be discussing the waiver law and the strategic waiver systems in Georgia and how that's impacting us in our classrooms every day. Until then, thank you for joining us for Rights at Night. Thank you for all you do for our students, and thank you for being a member of GAE. Have a good evening, everyone.